Wow, happy hump day. It's a lovely, glorious day. I got two stories here for you. Two stories piss me off. One pisses me off even more. I'll get to it later on. But there's an update to this story. Just when you think there's going to be no more plot twists, no more turns, now we find out District Attorney Jose P. Garza broke the law in order to convict Sergeant Daniel Perry of murder. That's right. District Attorney Jose Garza broke the law. But let me get to the story before I get into it. Daniel Perry murder case. Attorney files motions for retrial. Let's hear. The attorney of Sergeant Daniel Perry had filed motion for a new trial after jury recently found Perry guilty of murder in the death of Black Lives protester Garrett Foster on July 25th, 2020. The attorney alleges that court documents that key evidence was kept from the jurors and from them. The motion comes as Travis County Attorney Jose Garza wrote to the Texas Board of Pardons and Parole to request an appointment to present evidence to considered by the jury in Perry's murder trial. Garza also wants the board to hear the victim's family. The request comes days after Governor Greg Abbott calls for the board to pardon Perry. You can view the motion. I mean, it's 5 pages? Oh, it's 26 pages. I'm not going to read that because there's going to be a lot of legalese, most likely. The 26-page motion filed April 11th, Daniel Perry defense teams called for a new trial, comes after the jury conviction of Perry murdered on April 7th for shooting and killing the protester Garrett Foster in 2020. The motion details why the new trial is necessary by claiming key evidence was kept from the jury, which shows Foster and other protesters as the first aggressor. Several photos, including in motion, the defense claims that these photos were from a month before the incident and show Foster's attempt to stop cars using his girlfriend's wheelchair as other protesters swarmed the vehicle. Transcripts of the interview was done with Foster the day of the incident. Also included, when asked if Foster thinks that he'll use his rifle, he responded to, "No, I don't think. I mean, if I use it against the cops, I'm dead. I think all the people that hate us, want to say whatever, you're too big of a something to stop the actual do anything about it." The defense claims that the evidence would have proven Foster as the intimidator and proved that these protests were not as peaceful as some testimony led the jury to believe. Now, keep in mind that this video has been out there for a while. This particular one, not from the girlfriend stopping traffic and this dude looking for a confrontation. That is actually new on me. Let's see here. Not as peaceful as testimony as the jury to believe. The motion adds that the jury was subject to outside influence. According to the defense, jury revealed another juror conducted research at home during an overnight break. Presented that the research to the rest of the jury, it was also that an alternative jury did not verbally participate in deliberations, but did make reaction noises expressing displeasure with certain comments made by the jury. Defense claims that it was enough for a new trial. At the same time, the Texas Board of Pardons and Parole is looking into the possible recommendation of pardoning for Daniel Perry per the request made by Governor Abbott. The Texas Board of Pardons sent Fox 7 this statement. Chairman Gutierrez, the presiding officer of Texas Board of Pardons and Paroles, has received a request from Governor Abbott asking for an expedited investigation along with a recommendation as to pardon the U.S. Army Sergeant Daniel Perry. This board will be commencing the investigation immediately Upon the completion of the board, will report to the governor on the investigation to make the recommendation to the governor. The board has no further comment. There's no question that Governor Abbott's action has weakened the rule. Oh, there's no question that the Governor Abbott action has weakened the rule of law here in the state of Texas, and they have weakened our public safety here in Travis County, said Travis County District Attorney Jose Garza in an interview with Fox 7 Austin Monday. On April 11th, the DA Garza requested to meet with the board personally so he could present evidence considered by the jury in this case. A letter sent to the board. He asked them to review the trial transcripts, evidence from the trial official, and request input from Garrett Foster's family before making the final recommendation to the governor. My thoughts are with Foster's family. I know that they are heartbroken right now. I know justice feels incredibly elusive for them, said the DA Garza. Let's see here. But this right here has been withheld from the defense. You think if the defense knew about this, that they wouldn't have shown this? This withheld evidence to the defense. Now, this one right here is another one. Now, this one is old news. Keep in mind, this is old news. Ex-Texas prosecutor, first in history to be jailed for withholding evidence. The former Texas attorney agreed on Friday to serve 10 days in jail for withholding evidence that could have stopped an innocent man going to prison for 25 years. Apparently, the first-time prosecutor has been sent to jail for concealing evidence helpful to defense. Former Wilson County District Attorney Ken Anderson agreed to the plea deal that would also require him to, pretty much. First time the prosecutor be sent to jail, helpful for the defense. Let's go ahead and read a little bit of the story. Former Texas District agreed on Friday to serve 10 days in jail for withholding evidence that could have stopped an innocent man from going to prison for nearly 25 years. 10 days versus 25 years. Concealing evidence helpful to the defense. Former Wilson County District Attorney Ken Anderson agreed to the plea deal that would also require him to pay a $500 fine. So, 10 days in jail, $500 fine, and 500 hours of community service after this State District Judge Kelly Moore found him in contempt of court for telling a trial judge in 1987 that he had no exculpatory evidence to hand over to lawyers for Michael Morton, whose conviction of his wife's death was overturned in 2011. 25 years, and he serves 10 days in jail, $500 fine, and 500 hours of community service for a person serving 25 years in prison. How is that fair? How is that fair when your job is to uphold the laws of the land? You send a person to jail for 25 years when he was innocent. You withheld evidence to the defense that they couldn't use it to help their case. And he only serves 10 days in jail. If that doesn't piss you off, I don't know what does. Now, I don't know if this is going to happen to Jose Garza, but honestly, I don't know if this particular information would have changed it, because I'm coming to the conclusion that you had one idiot with an AK. You had one idiot from the Army. They met downtown, kicked off a series of events. They got what they wanted, and now they have to live with the consequences. I don't necessarily know if this right here would have swayed. I don't know if that's enough information, to be honest. I really don't. I don't know what this means. But I do know if this was withheld from the defense, Jose Garza, the DA of Travis County, broke the law and withheld evidence from the defense. But the other issue I have is this former person, only served 10 days in prison with a $500 fine and 500 hours of community service. That is not good enough punishment for when our public officials, our elected officials, fail to do their basic ethical duties of upholding the law and order of our state and country. He should have been served at least maybe 5 years in prison. Easily $10,000 in fines. Easily. I don't, because he literally sent someone to prison. He lied in 1987. Now, this was written in 2013. He lied in 1987 that he had no evidence to hand over to the lawyers for Michael Morton, and he only serves 10 days after he was convicted. When he was convicted to 25 years, I guess, because it was overturned in 2011. So probably, but that's over 20 years. 87, 97, which is 10 years. 2009, yeah, that's almost 20 years. This man was in prison for 20 years when he had evidence to hand over to the lawyers, and all he gets is 10 days. That's a slap in the face. It really is a slap in the face. It's like the immunity that the DAs get is unreal, and it needs to be reined in. There's got to be more severe actions for their consequences. I mean, 10 days is nothing. That's like a vacation. $500 fine. What's that? Nothing compared to what they make. And 500 hours of community service. Yay, you're picking up trash. Volunteering for government events. Yay. Oh, well, that's all I have today. I don't know how many more twists and turns this story's going to have, because just when you think this case is ending, there's another twist, there's another turn. I don't even know that he's going to get another trial, because I don't know if that's enough evidence to overturn the conviction. I mean, I'm pretty sure the lawyers want that, because they want another bite at the apple, because they get to charge Sgt Perry more money. Another 2 weeks worth of them being in trial, charging them. So the lawyers win. The only people that really lose is Sgt Perry and the victims. Well, not really. I guess I could call them victims. I mean, the loved ones of Garrett Foster. They had to suffer through another 2 weeks for the trial. I don't know. Leave a comment down below on what your thoughts are. I'm interested. That being said, have yourself a wonderful day, morning, or evening.